insurance company. Let the matter be listed on
Wednesday,
18th.
May it please your lordship, I beg to mention one IA of civil 17/26/2022 in MSCFL for withdrawal of the deposit money on 29.
29. 29 September. 29 September is Sunday.
Right.
Sorry, 2020.
20.
209.
Okay.
Lordship.
May I please? I would like to mention one MSc appeal. We will listed under order column. The lordship execution is going on against the appellant. And so it may come on 18 or 20 lordship.
Okay, on 20, we will try
20.
20.
May I plead your lordship, with the consent of the petitioner or your respondent, I beg to mention item number 54. Hearing matter, lordship. Lordship, may I pray to take up this matter any hearing date after vacation?
Why?
Lordship, actually this matter is led by Sri K.N. Chaudhary. Today he has some difficulty. One part matter is going on in court number 1 and that matter will take the whole day, lordship.
Okay, on the pair being made by Miss
R. Kakoti.
R.
Kakoti.
Learned counsel appearing on behalf of Mr. K.N. Chaudhary, learned counsel for the appellant. Recessal is the matter on
After vacation, any hearing?
after vacation. Okay.
22nd October.
Please, your lordship. Also, I beg to mention for listing lordship, MSC pin 235 of 2021 lordship. Hearing column lordship. That's why the insurance company has not been paying any lordship. Half of the money is not been paid. So, matter will be kindly for
In which column?
hearing column lordship.
Hearing column.
Yes.
Hearing column before vacation may not be possible.
What problems are parties are financially problem lordship. Here, insurance company has not been paid any money lordship. Half of the money is been paid.
Okay. 3rd of October.
May it please your lordship. Lordship, I beg to mention an item for motion, lordship. We are challenging transfer order, lordship. On Wednesday, lordship.
Wednesday.
Lordship. Obliged.
May I please your lordship, I beg to mention for RSA for orders after vacation.
May please your lordship, I beg to mention CRP IO for listing. Lordship, there is of course urgency in this case because the case in the lower court is fixed for tomorrow. So I beg before this court to allow the case to be listed tomorrow before this court. CRP IO.
Tomorrow is hearing day. Wednesday we will try. You inform the trial court.
May I please, your lordship, I pray for listing and make appeal for orders any date after vacation. Your lordship. It's all black.
May I please your lordship. I beg to mention listing of a CRP IO tomorrow, my lord. Because the matter is pending for.
Tomorrow not
cross-examination
possible.
tomorrow. My lord.
Tomorrow not
Wednesday,
possible.
my lord.
Wednesday possible.
Obliged.
May I please, lordship, I beg to mention item 40.
Item
40. Lordship. The senior conducting counsel is in Kolkata due to medical grounds, your lordship. So I, L. Hangzhou, appearing on behalf of S. Das, I beg to the matter to be adjourned for the your lordship.
your good name?
L. Hangzhou. L. Hangzhou.
Mr. L. Hanso, learned counsel appearing on behalf of Mr. S. Das. Learned counsel for the petitioner. You inform the other side.
Oh, yes.
You concern from the other side. Price for listing the matter when?
Any date is fine, your lordship. Any date is fine.
After vacation? Okay. Fair lot.
Much obliged.
Yes.
I have filed I to vacate the stay order lot and it was listed on 6-9 million, but not reached. So my friend, next Monday. It will be.
Daily list, item 1.
Please, your lordship.
Yes.
We may have a prayer for withdrawal of the second appeal because the parties have settled among themselves, my lord.
for withdrawal.
Yes.
Your good name?
P. Bora.
Pardon?
P. Bora.
Mr. P. Bora, learned counsel for the appellant, submits that he has the instruction to withdraw this appeal. Here is accordingly allowed. This appeal stands disposed of.
I'm appearing
on
for
withdrawal.
respondents. I'm appearing for respondents. P. Sunbi,
Is it necessary to record your presence?
my lord. I have the instruction there.
Because
sir.
he has the instruction to withdraw it.
My lord.
We are granting him
I come
permission
from,
to withdraw
yes, my
the.
lord. Settle outside, my lord.
Okay. On the ground that the matter has already been settled outside. Where is accordingly allowed, this RSA stands disposed of on withdrawal. Also heard Mr. P. Sundri, learned counsel for the respondent number 123 N5.
Public.
LCRB returned.
Much obliged.
There are three IO. It will technically be
Maybe. Civil division will not, in this case, I have filed in the effective division. I was defendant in title should be not, it was filed by the respondent. And that a revision is title should was not allowed, security in their favor. So I filed a title appeal Miller, and that appeal Miller to what happened during the course of Miller lockdown and after lockdown and misconduct of my advocate Miller. Anyway, Miller, that is, Miller, I could not, there was some delay, Miller, 1,000 about days, Miller, delay. And so I filed IA to condemn the delay. And delay, Miller, that was dismissed because my advocate did not accept. So, Miller, my friend, notice may go, Miller, and let them come.
But Mr. Rosid,
An order is, Miller,
whether
I have filed
the
a-
explanation so forthcoming from the applicant side
Miller,
is sufficient to condone the delay of
1,000 about days.
Yeah.
Yes.
yes.
That delay, Miller, actually, we have filed a miscase, that is, I have annexed it, Bureau Lordship, in this case, Miller, that else I have annexed here. What is my ground there, and Miller, why I could not, actually, I submitted all my relevant documents to my advocate, and then advocate, Miller, did not take care.
But unfortunately, you did not name the council also.
This is that I am told that he also expired by this time.
Pardon?
He has expired. I'm told, Miller.
No, that is not the
Right.
not the explanation.
There is
And also from the
there is an
impugn order, it
notice.
appears that after passing of the decree, you went to the
Pilot identity.
house of the respondent and threatened him to vacate the land.
No, land is in my possession. There is, apart from that, they have not yet come to vacate my land, and even they have not filed any Miller execution case at all. But they will file soon, very soon. That is, I am also instructed. So they will file Miller, and as soon as they will file, that is why I have not filed any state return yet. So my assumption is that it may go on notice and after
And it
notice-
appears that it has not been properly explained.
in my petition or in the court below, my lord. Court. That means what happened, my lord, I cannot explain more than that what they have explained there, my lord, and I
Mhm.
cannot either less or increase. And there in.
No, that's all right. Whether notice was issued. Here, notice was issued.
Is notice,
Whether notice was issued here or not.
I could not.
Whether notice was issued or not.
No, island notice or not issued. So that is I'm telling you, notice may go now. It was filed about 1 year ago, but there was one lapse on my part, because I filed additional affidavit, by which I have annexed them and made my dismissal order.
Okay, let notice go then.
My lord, yes. My also prayer.
Heard Mr. Rosid, learned counsel for the petitioner. This application under section 227 of the Constitution of India, read with section 115 of the CPC is preferred by 4 petitioners challenging the legality and validity of the impugned judgment and order dated 19/1/2009. Judgment and decree dated 19/1/2009, passed in TS number 10 of 2001 by the learned Munsif North Salmora, and the order dated 10/4/2023, passed in Mizze case number 35 of 2021. In TA number 1 of 2021 by the learned civil judge Poegao. It is to be noted here that by the impugned judgment and decree dated 19/1/2009, the learned Munsif Obhaipuri has granted ex parte decree in favor of the respondents herein, and by the impugned order dated 10/4/2023 in Mizze case number 35 of 2021, in title appeal number 1 of 2021, the learned civil judge Boygaon has dismissed the petition filed by the petitioner for condonation of delay of 1,000
1,035. 1,310 days. Page 80 below of my original episode.
$1,310 days.
Fine.
10 days. Peruse the petition and the documents enclosed therewith, and also peruse the impugned judgment and decree dated so and so so and so. That notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Must.
Hey, please, here this my MSc case was delay condition case was rejected, Lordship, and thereby MSc case was dismissed, Lordship. So I humbly submit notice may kindly be issued and records may kindly be called for.
Pardon?
Notice may kindly be issued and records may kindly be called for that MSc case was dismissed for condonation want of this condonation of delay petition, Lordship. That was rejected, Lordship.
No, first you show whether the order passed by the learned member MSCT is illegal.
Yes, Lordship.
How?
That is, FIR was lodged, Lordship. FIR was lodged immediately.
Hmm.
But the police paper FIR was there. So this is.
No, first you tell me whether there is a provision for condonation of delay in the new act.
No, Lordship.
First you tell me which act will apply, the old act or new act.
New act, Lordship. We have filed this new
Here
act.
new act will apply.
Yes. There
Are you
no
sure? When the accident took place?
Place of accident is this Thailand, Lordship. Amingaon jurisdiction, Lordship.
No, I am asking you On which date the accident took place?
2021, Lordship.
21. When the new act, I mean, came into force?
Yes, Lordship.
When the new act came into force?
Yes, Lordship. Oh, date 20, Lordship.
2020.
20. Yes, Lord.
Are you sure?
No, Lord, 22, Lordship. So there is chance for when FIR is there,
No,
Lordship.
if the accident took place prior to coming into force of the new act,
Yes, Lordship.
then which act will apply? The old act or the new act?
Old act will apply, Lordship.
Old act will,
Yes.
old act will apply.
Apply, Lord.
And then why you have filed the petition under the new act?
No, Lordship, this is amended, Lordship. That was amended, so 166 we have filed, Lordship. But there was no provision for limitation, Lordship, in the new act. But there is a certain, yes, in the indirect provision, there is one FIR is Lordship.
Okay, we will pass the order.
Well, this is an application under 210(7). The order, my lord, passed by the Honorable My Lord Special Tribunal constituted under Section 7 of the Land, My Lord Grabbing Act, Lordship. Here, my lord, we are the, if your lordship kindly chronology the facts, on 16/3/82, Assam State House.
You come to the order first.
My lord,
In order.
190, my
Page number
190,
190.
lordship.
One nine zero.
Your lordship.
Yes.
There, my lord, actually, because that we are the Assam State Housing Board, my lord. A statutory body constituted under the Assam State Housing Board Act, my lord. So we undertake various projects, my lord, but we acquire the land and then under construct various residential properties, my lord, and then it is either it is sold on give and rent, my lord. So in course of that on 16/3/1882, we purchased, my lord, 35 my lord, bighas of land, my lord, 35 odd bighas of land under different.
But the learned court below
Lordship.
has registered it as a session case number 325 of
It should
2019.
be registered as a land grabbing case, my lord. It should have been registered as land grabbing case. What I am submitting, my lord, when we find that there is a land grabbing, we file an FIR before the, my lord, Hatigao police station, my lord. But in view of the division bench judgment, in this case, of this court, my lord, we said that by police is now authority to investigate, it should be referred to the special tribunal constituted under section of the Assam Land Grabbing Prohibition Act. They referred it to the, my lord, the special court of the district judge, my lord, which is constituted as a special tribunal for land grabbing. He registered that case on the basis of that reference, my lord. It's a suo motu registration. We did not make any application. There are two ways of, my lord, filing application. If my land is grabbed, if I allege that my land is grabbed, I can file a petition under Section 8, Rule 2, Section 8, Subsection 2. Or the court can suo motu register a case, my lord. If it is comes to the knowledge of the case, otherwise that it's a case of alleged land grabbing, my lord. So in that case, my lord, we filed a FIR before the Hatigao police station. Hatigao police station initially registered the case, and after registration of the case, made some preliminary investigation. But in view of the decision of the division bench of this honorable court, my lord, I'll just refer it to your lordship. It is, my lord, 2017 5 GLT 854. The division bench held that police has no authority investigation, so far the allegation of land grabbing is concerned under Section 4.
No, in that case, you ought to have challenged the order by which the session case number so and so was registered. Have you challenged that order?
I am the petitioner there. Before I have filed the FIR. Case is registered. Court has issued the notice upon all the parties. We filed our written statement. Then the tribunal called for a report from the circle officer. Now, if your lordship kindly look into the imping order, there is no expiring of our written statement. Then no one is discussion anywhere of our written statement. Court has issued a notice to us. We filed a.
No, the problem is that this has been registered as session case.
No, my lord, this is, but it is land grabbing case. It's all the letter on it is said it's a land grabbing case. If your lordship look into the orders.
You are challenging the order passed in session case number 325 of 2019.
It is registered as such, my,
Hmm.
by the court of my lord, but it is before the land grabbing special tribunal. If your lordship look into page 93 of the, now lordship will kindly see page 92 first, how the case was restored. This is the, my lord, that how the proceeding was set in motion by the special tribunal. Page 92, lordship kindly see. This is an order of 13/5/19. In personal judgment of Honorable High Court, in criminal reference number 1 of so and so, dated so and so, instant case has been registered and transferred in the court of London Special Tribunal for Assam Land Grabbing Prohibition Act 2000, Kam District Session and Judge. So it was manner registered under Assam Land and Assam, my lord, Land Grabbing Prohibition Act, my lord. Though it is mentioned as session case, but it is registered under Assam Land Grabbing Act. Eventually, order was passed under that act only. Somehow it is let in the session land grabbing case also by the learned court below. One case book. 93, if your lordship will look into page 93. Now 93, lordship will find down below, my lord. Session land grabbing case, LG case. It's an order of 8/11/2019.
811.
2019, page 93. If your lordship, order of 8/11/2019. Landed council petition or file petition number so and so, seeking another date for appearance, session LG case number 325. It is the same case number, session land grabbing.
8/11/2019.
Yes, ma'am. Lordship page 93.
90.
3, ma'am. Page 93. If the lordship will be, that is type portion, ma'am. It is appeared from page 95 also, my lord. That is the order of the court, my lord. Page 91 of the court. Page 95 also, lordship, session LG case number on the top of the LG case number, session LG case number 325 of 90. So virtually it is registered under Assam Land Grabbing Prohibition Act of 2010, which is emanates from the order of 13/5/2019.
So we set aside the order, we remand the matter to the trial court to afford you an opportunity of being heard.
Yes, that will do, lordship. I respectfully agree with your lordship.
Where is the FIR?
That will be reported there. Lordship will find it from. Lordship will find it from page, my lord, it will start from page 90, my lord. How this case was referred by the,
No, where is the FIR? Page 90.
page 90 is the my lord reference. By the lordship will find everything there.
No, the housing board has filed on FIR.
Yeah, file, my.
Where is that FIR?
FIR copy, my lord. We have not, and because it is already been referred, my lord, but I have a copy, my lord, but lordship will find the abstract in page 90, my lord. If your lordship kindly look into page 90.
Okay.
Page 90, my lord, will
Heard, Mr.
BJ Ghosh.
Learned counsel for the petitioner. Correctness or otherwise of the order dated 2/3/2024 passed by the learned additional district and session judge Kamrup M. Being the special tribunal constituted under section 7 of the Assam Land Grabbing within bracket Prohibition Act 2010. In session case number 325 of 2019 is challenged in this petition under Article 227 of the Constitution of India. It is to be noted here that by the impugn order dated so and so, the learned sessions additional session judge has dismissed the session case number 325 of 2019 on the basis of a report furnished by Circle Officer. Circle Officer of
Hardcore officer of the Dispute Revenue Circle.
Dispute Revenue Circle. The learned counsel for the petitioner submits that the petitioner has filed one FIR in respect of
My lord will find.
grabbing of its land measuring 4 kotha, which in bracket approx, covered by Doug number 286 of Karaspatta number 91.
Lordship will find the detail in paragraph 9 of our petition, page 7. We have detailed how this FIR was filed, under what circumstances that FIR was filed. Page 9, para 9 of page 7 of our petition. There we have.
At the instance of one Sri Alok Roy,
Yes, yes.
respondent number 1. Before the officer enters Hatigao Police Station. Upon the said FIR, the officer enters Hatigao Police Station registered a case being Hatigao PS case number 90 of 2019 under section 447, reduced section 4 and 5 of Assam Land Grabbing within bracket Prohibition Act 2010. Thereafter, on 10/4/2019, the IO of the said case referred the Hatigao PS case number 90 of 2019 to the learned special tribunal for taking cognizance of the offense of land grabbing against the respondent number 1 and 2. Thereafter, the learned session judge Kamrup M, by the order dated 13/5/2019, so motu registered a case being session case number 90 of 2019. No. So Motu referred the case number 90 of 2019 as session case number 325 of 2019. And thereafter transferred the case to the file of Learned Special Tribunal for Assam Land Grabbing Prohibition Act 2010. Kam Additional District and Session Judge number 1 Kamrup M for disposal. Thereafter, the Learned Additional Session Judge has called for a report from the Circle Officer, Dispur Revenue Circle, by the order dated. Where is that order?
My lord will find that order.
By the order dated 23rd 8 2023. 101 page number.
My lord, page 101, 23/8/2023.
101
Yes. my lord.
page number.
Yes, lordship.
23rd 8 2023 has called for a report from the Circle Officer. And thereafter, the Learned Tribunal, on receipt of a report from the Circle Officer, by the order dated 2/3/2024, impugn order dated 2/3/2024, has dismissed the case without taking cognizance. The Learned Counsel for the petitioner submits that the impugn order was passed without hearing the petitioner.
One thing, my lord, may I, so my lord, because they did not also take into account, because the impin order, nothing discernible from the impin order. My lord, that the initial deposition which you filed in response of the notice of.
When you have filed the initial deposition.
My lord, that my lord will find it. It start from my lord, page lordship will find. Page 104.
No, that order, in which order it is reflected that you have filed the
My lord, that. my-
initial deposition.
My lord will find. That my lord will find.
The Learned Counsel for the petitioner submits that the petitioner has furnished the initial deposition on affidavit on 22/5/2023.
2023.
When it was filed, initial deposition.
Yes, my lord. 28/3/2023. My lord, page 109, it is reflected. Or, my lord, 23/8/2020, complainant Assam State Housing Board submitted an initial deposition. So its commissioner. Annexed with photocopies of supporting documents.
On 23rd of August
Yes.
2023. But the Learned Tribunal, without taking into account of the same and without giving an opportunity of being heard to the petitioner, dismiss the case. Therefore, the Learned Counsel for the petitioner submits that the impugn order fails to withstand the legal scrutiny and therefore it is contended to set it aside and to remand the matter back to the Learned Tribunal to afford to hear the matter afresh and to pass necessary order after affording opportunity of being heard to the petitioner. Having heard the submission of Learned Counsel for the petitioner, I have carefully gone to the petition and the documents placed on the record and also perused the impugn order dated 2/3/2024. It appears that the Learned Tribunal, by the impugn order dated so and so, without giving an opportunity of being heard to the petitioner, has dismissed the case and without taking any cognizance and even without taking into account the initial deposition filed by the petitioner before it. In that view of the matter, the impugned order failed to withstand the legal scrutiny and accordingly the same is then set aside. The matter is remanded back to the learned tribunal to afford an opportunity of being heard to the petitioner and thereafter to pass necessary order. In terms of above this, CRP IO stands disposal at this motion stage itself.
My lord, in this case, the present petitioner filed a divorce petition against the respondent in the court of Ladakh District Judge Dorong since 10 years or 12 years ago. And the said case is pending there by virtue of a transfer order passed by this honorable court in the year 2013. And on the transmission of case records, two issues was framed in this case for determination of the case of the present petitioner. One was that the present petitioner suspected that the previous marriage of the respondent is existing. And second issue was her conduct was she was insane, not competent to solemnize the marriage. So, but suddenly after filing of written statement of the respondent, she has produced a decree, judgment and decree in the name of one Priyanka Das. But that was mechanically accepted by the then District Judge Dorong, but without any hearing, without any proper format. Since the issue of bigamy has been dropped, and on the issue of insanity, the case was proceeded. But subsequently, my lord, on last year in the month of July, on the basis of evidence on record, the present petitioner filed a petition number 556, along with another petition for use of secondary evidence. And while filing the petition, the petitioner has contended some 4 issues why the said issue should be to be recasted. Which
No,
was earlier,
why recasting of the issue is
Yes,
necessary?
necessary.
Because earlier it was a draft.
Yes, Lordship may come to page 25 and 26. Page 25 and 26, paragraph 3, at page 25, my lord. This is the version of the above named respondent, wherein in paragraph 3A, 1/4 factor for quoted before this trial court that I have not submitted before the court any decree of this case in my name as Aparajita Das. Number B, I have not mentioned whether in my written statement as well as in my evidence on affidavit that Priyanka Das and Aparajita Das is the one and same person. Number C, after solution, it was wrongly typed there. Resolution of the first marriage, I changed my name from Priyanka to Aparajita Das by wearing a swearing a affidavit notary before the notary public. But that affidavit was thereafter, my lord, D. This is our version of the present opposite party, my lord, who is my wife. A copy of the said affidavit as to the change of my name has not been submitted in this case. There is no document, my lord, in support of our claim. I did not publish as regards to the change of my name in any newspaper, nor was it given at any gazette notification. Number F, it is not a fact that the said, this is irrelevant, my lord. Number G, I did not submit the decree of divorce at the time of special marriage, but submitted some documents which I do not remember now. Next, in paragraph 4, this is the version of DW2, who was his mother, her mother. Number A, I have signed in the marriage certificate dated 29/11 with one Borisankar Das, which was registered as a special marriage between the opponent parties, despite there was no decree of divorce in the name of my daughter. Number B, the name of my 3 daughters are Mosumi Das, Aparajita Das, and Susmita Das, and the name of my son is Mitun Das. Number C, Aparajita was earlier married with one Surjit Das. That is, so in paragraph next, coming to page 7, my lord, the petition which was filed before the trial court, my lord, page 6, paragraph 6, my lord. May I read out? That the petitioner further submits that in criminal petition number 138/18, filed by the petitioner before the Honorable Guwahati High Court. The opposite party on 7/4/21 filed her affidavit in reply, wherein it was contended that the opposite party has changed her name from Priyanka to Aparajita by swearing an affidavit dated 3/6/2008 before the notary Dorong, Mangoldoi. On the contrary, during her cross-examination in the instant case, the above named opposite party stated that after dissolution of her first marriage, I changed my name from Priyanka to Aparajita by swearing an affidavit. Now, my lord, if she changed her name on 3/6/2008, Priyanka to Aparajita. On the other hand, my lord, the decree was produced by her. It was on 16/2/2010. So how it shall be applicable? So very mechanically learned trial judge came to conclusion that both these persons are one and same. So which ought not to be without any evidence. So at least final pronouncement of judgment of the issue should not be answered. That is the settled proposition of law as contemplated in CPC.
Where, when the decree was granted,
Decree was granted 16/2/2010.
have you enclosed the
Annexed,
decree
I have
here?
annexed, yes. Fine. Annexure 4, my lord. Annexure 4,
Page number,
42 onwards.
page number,
42 onwards. 4. Relevant part, lordship will find page 44, 44. Here is, my lord, Surjit Das was petitioner and one Priyanka Das is the respondent. It is the cause title of the said judgment. So on the basis of this decree produced by this lady, the learned trial court was pleased to drop the issue, which ought not to be. So on the basis of the subsequent development of the case, we have filed the only petition merely with a prayer for to recast the issue, not for determination of final whether she is Priyanka or Aparajita. That to be answered.
no, she
And it-
itself admitted that she is one and the same person.
No, nowhere submitted.
Hmm?
She never stated.
No,
it
in the order dated, it is reflected,
No,
in order, it is
that's why we
reflected.
have approached. Yes, yes. That is the only reason we have approached before your lordship. That observation nowhere, even if your lordship would peruse her written statement filed thereof, no, even her deposition also speaks that she has not submitted any document, any statement that she is the one and same person. And merely saying, I may say that I am Narendra Modi, how it can be possible? Somewhere I say I am Narendra Modi, somewhere I can say I am Amit Shah. Is it possible? Only mere saying and declaring without any appropriate document. In bank, my lord, one word if miss out from any document or one handwriting here or there, then
No, the
suspect document will come out.
order for dropping the issue
Yes, lordship
was
will-
passed on 26/5/2014.
14.
So by that
So-
time,
So at this stage, my lord, need of the hour is that to hear the opposite party with regard to this cloud arose with regard to her identity, because my issue was first of all that her marriage may be existing with previous marriage. That's to escape from the issue offense of bigamy. I have filed the divorce petition. So at this stage, if such type of suspicion continues, so it was the proper for the learned trial court to recast the issue and it to be answered finally, not before the trial been concluded in this case. So
no,
this,
when the marriage of the respondent with the present petitioner was solemnized,
29 November 2011.
2011.
Yes. And it was as per her petition, it was transferred to the court of learned.
2011, and the suit was disposed of on 5/2/2010.
No. Earlier.
No, the earlier divorce was granted on 5/2/2010.
10 between someone else, because prior to solemnization of marriage, both this solemnize this marriage with both are divorcee. This was not first marriage for me, this was not first marriage for her. Both are divorcee. But with regard to the marital status, she has not produced on the day of solemnization of marriage any decree of divorce. That is clear from her deposition itself, which I have read out before your lordship today. And these are part of evidence on record before the learned trial court. And these aspects are nowhere considered by the learned trial court while adjudicating my petition number 556. Nothing, no reasons has been assigned. Yes, and so far as my lord, as per law, my lord, in this judgment, this honorable court, with reference to honorable Supreme Court judgment, Order 14 Rule 5 CPC authorizes the court to amend and strike out any issues, including power to frame additional issues or to recast issues already framed in the case of Bachchan Devi versus Nagar Nigam, so and so reported in the Honorable Apex Court held that the power of the first appellate court is coextensive and with that of the trial court under the code, and that
So
the
that's
first
all right.
appellate court can-
First you tell me marriage was solemnized on date of solemnization of marriage with the
29/11/11.
present petitioner was
29 November 2011.
29 November 2011. And the earlier marriage was
Resolved on
dissolved on 5/2/2010.
16 February 2010.
16 or 5?
16, TSD 509. That case number was TSD 509, 2009, in the same court, district court. Lordship, there is the page 42, case number is there. Yeah, not 42, actually, Lordship will find at page 44. 44 and 43, TSD 509, in the same district court, my lord.
So how the bigamy search can be framed? Because marriage was dissolved on 16 to
That is
2010.
the question mark and with the issue, because there was one case, so for lordship, just for memory, I would like to repeat, which I have appeared in Rina Boro. There was some Rina Boro. I have implemented her as respondent number 4 along with the state government. So that Rina Boro name is same, both father's name is same, locality is same. But ultimately hearing this petition after 3.5 years, conducting proper inquiry, it found that the respondent number 4, my opposite party, was false. He has never appeared in the examination. It is a case of PTAD and it is reported judgment 2017. In this case, this honorable court held that she has been removed from service by virtue of this honorable court, despite having all similarity. Because she has
that is a
not
a
appeared
different
in the
aspect.
examination.
Mr. Pal, you come
So-
to the issue.
So
Her marriage was dissolved on 16 to 2010.
your lordship
And
cannot
her marriage
know.
was solemnized with you on 29/11/2011.
That's the issue. That's the very interesting issue. I am not terming that this was the person who was married with Surjit Das. She is the one and same person. I am not terming that at this stage of proceeding, because her entire deposition as well as the document itself not supporting her identity. It may be someone different. It may be a case of impersonation. So
Maybe whether there is any such averment in your plaint
yes,
or in her written statement.
everywhere in my plaint, everywhere. That's why that on the without
Where
including-
is the plaint?
that was the original petition, my lord.
No.
On which is
Where is the copy of plaint?
what I have read out before, your lordship.
No, have you enclosed it with this petition?
Amended, the original plaint is not annexed here. And then I have my main basic challenge was before the learned trial court for by seeking nullity of marriage on with my apprehension that it is a case, maybe a case of bigamy. Her previous marriage of my wife is may be existing. And second one is her conduct was not normal. So there was two grounds, particularly before
No,
seeking the
no,
case of.
we are not concerned with the other ground. We are concerned with only the issue of bigamy.
Yes, but this document, post title of the divorce decree produced by her is not supporting the present identity of the respondent and merely saying that I am.
Maybe, she has explained in the affidavit that
explained,
she
not
has changed
explained.
her name.
No, I have, I can repeat it, Lordship may repeatedly check it, paragraph 25(6), my lord. I have read out, this is her own version. This is not my version, I have quoted. Prima facie argument of, I have read out clearly, my lord, before your lordship. I have not submitted, may I read out again? In para 3A, I have not submitted before the court any decree of this case in the name of.
You are reading paragraph number?
Paragraph 3A in page 25. These are her version, not my version.
Okay, let notice go ahead. This
Yes.
is, let's see.
In the meantime, because for your lordship query, my lord, proceeding is at final stage. Only re-examination of the respondent is awaited and next date final argument. So before that, the proceeding to be stayed, my lord, subjected to
Maybe, but
subject to payment of monthly.
there appears to be no merit in this petition.
My lord.
Oh, we are
My
not inclined to grant any.
No, if your lordship would not stay, there would be effective proceeding will go on. And this, if this proceeding is pending the year, so we would not have any purpose shall be served of the petitioner in
Maybe,
pending this petition.
maybe
So it may be a time bound hearing of this case.
if earlier marriage was dissolved on 16 to
No,
2010.
that's the issue. That's the issue for determination, my lord.
Maybe,
Not
maybe.
at this stage today, we cannot come to conclusion that that was her previous marriage, that was the same person. That is the issue to be kept it pending for determination and adjudication before
No,
this court.
stay, let the other side appear there.
Yes,
We'll
yes,
consider.
let them clarify it and subjected to.
Or Mr. A. Paul, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness of the order dated 8/8/2024, passed in petition number 556 of 2024, dated
23 months.
21/7/2023, corresponding to TS within bracket D number 29 of 2013 by the learned District Judge Dorong Mongoldoy. It is to be noted here that by impugn order dated so and so, the learned District Judge Mongoldoy, Dorong Mongoldoy has dismissed the petition filed by the petition number 556 of 2024, filed by the
23
petitioner for
556.
recasting one issue. On recasting the issue of bigamy. Having heard the submission of honor, there is the petition and the documents placed on record, and also there is the impugn order dated 8/8/2024. Let notice be issued to the respondent, returnable in 4 weeks.
Under date to be fixed in this case, date to be fixed, because proceeding is there. I am ready to pay monthly maintenance on each and every first week of every calendar month before the trial court. Otherwise, I will.
No, this
gladly-
proceeding has nothing to do with your maintenance proceeding.
Yes, I am ready to pay on each and first week of every month, the monthly maintenance, subjected to conditional.
Notice be issued to returnable in 4 weeks. A step be taken by registered post with AD. And also by usual process within a week from today. Justice service is also permitted. List the matter after 4 weeks.
My lord, in the meantime, effective proceeding of the case may be stayed. Otherwise, if your lordship, we. if
Entire
it-
period of the petitioner will be considered on appearance of the other side.
My lord, it will be some urgency
No,
because issue
no.
is very serious, my lord.
No, no.
Because case is at conclusive stage, my lord. Case is at conclusive stage, my lord. There are two
We'll see.
probable dates are here, my lord. That's
Because
why I am
the
not stopping her maintenance.
the respondent has filed an affidavit that she has changed her name. That affidavit is on the record.
No, everything may be, whatever proceeding, let them come up. Till then, my lord, there are
No,
two
no,
probable proceedings
no,
before the
no
trial
stay
court
at
for
this stage.
finalization of the case.
Sorry. We are not rejecting your pair, but we will consider on appearance of the other side.
Then, my lord, a date may kindly be fixed. Otherwise, it will
After
be,
4 weeks,
no, time bound manner, it would be hard. Otherwise, it
Maybe,
will be great
maybe.
prejudice there, without stay, without, if this.
after 4 weeks, one date.
Obliged.
Item number?
May I praise your lordship?
Yes.
Lordship, here the petitioner was serving as a grade 4 staff and he was seeking promotion to the cadre of junior assistant. Now, lordship, in the meantime, we have lost contact with the petitioner. And from the affidavit, it seems that in 2017, he was aged about 54 years. So he might have superannuated from service in the meantime, 7 years down the line, lordship.
Already superannuated.
It seems, so, lordship, we have lost contact, but from the affidavit, it seems that in 2017, his age was 54. Therefore, now he must be around 61 years of age in 2024. But we have lost.
Now you have no contract
We
with
have
him.
no contact. We have tried to, but we could not establish any contact with the petitioner.
What to do then?
Your lordship may dispose it off with liberty that if he is aggrieved, he may come up thereafter because we have we could not, we tried our best, but we could not any establish contact with the petitioner.
No, if you could not contract with him, then the registry will issue notice to him, or whether you have issued notice to him.
No, lordship, the registry may issue notice that
Okay, heard me, sir.
A. Chakraborty, lordship.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that he has lost contract with the petitioner. With the petitioner. Accordingly, it is provided that a RSS shall issue notice to the petitioner. And list the matter after 4 weeks.
Lordship. Obliged.
Item 9.
May I please your lordship? My lord, we need some more time to file affidavit in reply to the affidavit in opposition filed by the respondents.
Heard, miss, your good name?
A. Bora, Mrs. A. Bora.
Learned counsel for the petitioner, and Mr. Aman, learned counsel for the respondent number
8 to 16.
8 to 16, and for rest of the respondent,
Lordship, I appear for respondent number 1, 3, and 5.
1, 3, and 5.
Yes, your lordship.
I will be for 2. 1, 3, and 5. The learned counsel appearing for the petitioner submits that she may be granted how many weeks?
2-3 weeks would be enough.
2 weeks to file a reply to the affidavit in opposition filed by respondent number.
So we are for the petitioner.
Pardon?
We are for the petitioner.
You want to file a reply to the affidavit.
Affidavit in opposition, filed by the respondents.
All the respondents have filed their affidavit or against a particular respondent.
No, sir, all the respondents.
She says all the respondents.
All the respondents. No, whether all the respondents file affidavit here.
Yes, your lordship. Lordship, we have filed an affidavit.
3, 5, and we have also filed. 8 to 16 have also filed.
You have a
You have not filed. Respondent number 2 have not filed, Lordship.
respondent number 2. You have good name?
I'm S. Dr. Lordship. But Lordship, DC whatever, DC stand will be our stand, Lordship.
Acha. Here is allowed. Recessal is a matter after 2 weeks.
May I please, Lordship, for timing my senior leg another court, Lordship.
Pardon?
For timing, Lordship,
Time being,
my senior leg, Lordship.
okay. Yes, yes.
Your Lordship, this matter pertains to the claim of regularization of the petitioner as a lecturer in West Gwalpara College. Now, this is a second round of litigation. Your Lordship will kindly come to page 89. Page 89, Your Lordship.
Yes, 89 is the order.
Yes, it's an order, Your Lordship, which has been passed in WPC 166 of 2018. Your Lordship will kindly
My
come
lord,
to 90.
my lord, in this case, I found that an affidavit has been filed, but copy has been not served on me. That is why I could not file affidavit, my lord. Let us have a at least one copy may be served to me, my lord. Yes,
Copy of affidavit filed by
filed by principal.
respondent number.
Serve within the course of the day, Lordship. I'm not
Respondent number.
aware
You are
any
for
of-
respondent number
By,
4, Lordship.
4.
I am 5.
It was not within my knowledge. If he could have informed me, I will.
No, just I just said that
Lord,
on that
within the
affidavit
course
has
of
been
the day, I
filed.
will.
I am waiting that some affidavit is to be.
It
yeah.
was filed long back, 26/6/2023. Maybe it was served only upon the petitioners.
Over me at least.
Heard Mr. M. Sharma, learned counsel for the petitioner, and Mr. J. Ahmed, learned counsel for the respondent
Respondent
number
5.
5. And Ms. R. Chaudhary, learned counsel for the respondent number 4. And for rest of the respondent,
1 and 12.
1 and 2.
Yeah.
1 and 2. For respondent number 1 and 2. Mr. Ahmed, learned counsel for the respondent number 5, submits that he has not been furnished with a copy of the affidavit in opposition filed by respondent number 4. Ms. Chaudhary, learned counsel for the respondent number 4, undertakes to serve a copy of the affidavit to Mr. Ahmed during the course of the day. List the matter on.
My lord, another, the affidavit from the director is very much necessary because in this case, their affidavit is very much necessary. That is why I am handicapped not filing the affidavit. Because if their affidavit is, they should file affidavit. My lord.
No, you cannot compel them to file
Oh, yes, my
affidavit.
lord. But let this matter be listed for final disposal after vacation.
After vacation.
My lord.
Okay. Accordingly,
In
it
the
is
meantime, I
provided
will
that
file-
Recess shall list the matter after vacation.
Yes.
May please, your lordship. This is an appeal against the MSCT award one for enhancement, my lord. So the notice may be issued.
Enhancement on what ground?
Ground because of calculation, my lord. Previous injury that is not taken into effect, my lord.
Injury was not taken into account.
Effect, no. They have taken it as a simple injury, whereas under 320, when the police report came there, it is a grievous injury. So under 320 of the CRPC, my lord, IPC, my lord, grievous injury is given there. At least 2,50,000 is a mandatory, my lord, in the grievous injury. As per the MSCT Act, my lord. the new
Is
act.
there any disability?
My lord,
Is there any disability?
my lord, disability is not there, but grievous injury, I have explained here, my lord. The lordship will, he has not discussed anything about the injury, whether it is a grievous injury or simple injury. He's done just simple.
Have
say-
you filed any injury
Yes, my-
report?
Yes, yes, I have given the report. Your lordship will come to the judgment page, my lord.
Page number,
Judgment page, my lord, 15, my lord.
paragraph number,
Paragraph 15, my lord, paragraph number. My lord, issue, paragraph number 12, my lord, page 18. The issue has been fixed.
And where is the discussion?
Nothing, they have not discussed anything, my lord, simply pass the judgment, my lord. That is what, my lord, one of my ground is page 7, my lord, paragraph 8, your lordship will see the ground, my lord.
Part Mr. K. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of the MP Act is directed against the judgment and award dated 2/1/2024 passed by the learned member MSCT Sonitpur in MSC case number 11 of 2020 which indicate injury filed under section 166 of the MP Act 1988. Mr. Bhattacharya, learned counsel for the appellant, submits that this appeal is referred for enhancement of the awarded amount, enhancement of the compensation amount. Taking this court through the judgment, impugned judgment, Mr. Bhattacharya submits that though an issue has been framed by the learned trial court in the impugned judgment, yet nothing has been discussed and awarded a sum of rupees 1,52,814. Be that as it may, let notice be issued to the respondent returnable in 4 weeks. Step be taken by register post with AD and also by usual process within a week from today. Recess will call for the record from the learned tribunal. List the matter after 4 weeks.
Right. Same matter, my lord.
Same.
The same injury, my lord, without any discussion. So grievous heart is there.
Arising out of same accident,
No, my lord, it's separate.
different accident.
Okay. But the matter is same, my lord. Injury they have not discussed about.
Okay. Same.
13 are same, my lord. All injury.
14 is same.
No, 13. 14 is same, my lord. 14 is same. Because
12, 13 and 14 same.
12, 13, 14 are same injury matter, my lord. They have
Okay.
not discussed.
Okay.
Your lordship, this appeal has been filed for enhancement of the award.
Okay. Award means
AG Chaudhary, your lordship. AG Chaudhary.
AG Chaudhary, learned counsel for the appellant. This appeal under section 173 of the MP Act is directed against the judgment and award passed by the learned member Motor Accident Claim Tribunal number 3 Kamrup M Guwahati in
Your lordship, there's a typographical mistake. The MSC case number should be 228. Wrongly, I've written 231. 20th of 2019.
the correct number is
228, 2019.
Piccolo. Judgment and award dated 12/6/2024 passed by the learned member Motor Accident Claim Tribunal number 3 Kamrup M in MSC case number 228 of 2019. Is to be noted here by the impugned judgment and award dated so and so, the learned member Motor Accident Claim Tribunal number 3 Kamrup M has awarded a sum of rupees 16,68,775 as compensation to the petitioner. No, compensation to the claimant, Noyan Money Bordola. Noyan Money Bordola. Where is the memo of appeal and the grounds mentioned therein?
For your lordship, though the claimant has sustained 75% of disability, but the court has considered only 50% of disability, your lordship.
75% disability is assessed by the doctor.
Yes, your lordship. In page number, your lordship.
Maybe, but functional disability may be less than that amount, that 75%.
But the doctor has stated that the chances of recovery
The
is.
court is not bound by the member of the tribunal is not bound by the disability certificate issued by the doctor. Mhm. The learned counsel for the appellant submits that while assessing the compensation, the learned tribunal has assessed the disability of the appellant as 50%. But as per the disability certificate, his disability was assessed at 75%. And as such, the assessment of the learned tribunal is erroneous and liable to be set aside. The submission of learned counsel for the appellant needs further consideration. At this stage, admit the appeal. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Call for the recessal call for the record from the learned tribunal. List the matter after 4 weeks.
Same, your lordship. Is the same cause of accident, your lordship.
Same,
Yes, your lordship.
same order.
May it please your lordship. So this is an MSc appeal, lordship. The ground is that, my lord, the insurance company has been saddled with liability. Despite the fact that the driver of the vehicle was not having any driving license, that was apparent from the police papers relied upon by the claimant himself, lordship. And if there is a violation of section 5 of the MB Act on the part of the owner of the vehicle. That is the ground, my lord.
Heard Mr. Colita, learned counsel for the appellant. This appeal under section 173 of the MB Act is preferred by the appellant, National Insurance Company Limited, challenging the correctness of the impugned judgment and award dated 18/6/2024, passed by the learned member Motor Accident Claim Tribunal, cum additional district judge FTC, Dibrugarh in MSC case number 15 of 2022. Where is the memo of appeal and the grounds mentioned therein? Admit, let not, now also where is the impugned judgment and award dated so. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by the process within and from today. Recessal call for the record from the learned tribunal. List the matter after 4 weeks.
Lordship, one I is there, lordship.
So 50% of the awarded amount
Lordship.
within 2 weeks from today.
Lordship.
I dispose of.
Lordship. Macho.
Lordship, this is a statutory appeal, lordship. There are involvement of 2 vehicles in the accident, lordship.
accident took place due to head-on collision between two vehicles, Lordship. But victim was driving the other vehicle with a learner license only. Our contention is that accident took place due to wrong driving of the vehicle by the victim. But Lordship, entire liability is fixed on the present appellant. Accident information report shows that vehicle of the victim was driving only, and no charge sheet is filed against our vehicle. This is also regarding recent negligent driving of our vehicle and regarding monthly income of the victim. The learned trial court Lordship took 24,000 without any basis. Lordship, there is no income tax return, no proof that you had earned 24,000 per month. Lordship. So quantum is on the other side, Lordship, higher side. Lordship. These are the grounds of appeal.
Heard Mr. S.S. Soikia, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 13/5/2024, passed by the member, learned member, MSCT. Come additional Judge FTC Digubur and MSC case number 57 of 2020. It is to be noted here that by impugned judgment and award dated so and so, the learned tribunal has directed the appellant to pay a sum of rupees 52 lakhs 10,800 with 6% interest to be paid with effect from the date of claim petition, that is 11/11/2022. There is the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar shall call for the record from the learned tribunal. This is the matter after 4 weeks. There is
There is a caveat, Lordship. I am appearing on respondent number 1, Lordship.
yes. Caveat or the art,
No,
caveat stands on this side.
minus.
Any objection?
No objection, Lordship. There is statutory appeal, Lordship. Regarding the stay, Lordship, some amount may be deposited, some percentage.
Yes, 50%. 50%. We're disposing of the appeal. I.
Okay.
So within 2 weeks from today, we have to deposit the amount before the registry of this court. Oh,
Problem.
This matter is relating to selection and appointment of junior assistant.
volume.
None of the respondent lordship has filed affidavit in date lordship, although this is a matter of 2019.
My affidavit is ready, my lord. I'll file it today itself. I am the selected candidate, my lord, who is working in the school, but earlier they have approached thrice. And in all the cases, my lord, they have withdrawn or directed dismissed this. They have annexed their copies by twice. But
You are for respondent number
I am for respondent number 5, my lord.
5.
Selected candidate. I'll file the affidavit today itself, my lord.
So far, answer script is perhaps lordship, original answer script will require lordship. So respondent number 4 lordship may be directed to produce the report of.
Who is for respondent number 4?
Respondent is the selection.
Election committee, my lord.
Because so many overwritings so given, I have given the answer script that was obtained through RTI. And initially, lordship, in the first round of litigation, lordship, the matter was remanded, direction was given to reassess the answer script. When lordship, 5 marks has been increased in respect of petitioner, and 3 marks has increased in respect of the respondent number 5. Even that lordship, some anomalies are still remain.
So who represents respondent number 4?
I am respondent number represented by my headmaster, my lord.
But respondent number 4, the name of the respondent has shown in the first list. one,
Okay, then let him file affidavit.
my lord. Yes, yes.
Heard Mr. M. Khan, learned counsel for the petitioner. And Mr. Biswas, learned counsel for the respondent number
5 minutes.
5. And Mr. Thakuria, you are for respondent number 1, 2, and 3. Then who represents for then? You are.
Yes.
Your good name?
Yes, yes, Borua.
Borua. So the counsel for the petitioner submits that this affidavit of respondent number 4 is necessary.
Yes, yes.
Necessary party.
আমাকে একটা copy দিও। They have filed the affidavit, man.
Already filed.
My learned friend has.
Already filed.
Yes.
No, no. In this.
And there is also a pair that the answer script may be produced before the court. Are you in a position to produce the same?
My lord, this case is pending. Time and again they are coming. It is from 2014 to selection 2015. And my Lord Justice Pathak has returned back the case for reassessment, and reassessment was done. They are not satisfied. Now again they have come for further reassessment.
Still anomalies are there, Lordship. I will sue on that one. I don't know
Okay.
why my learned friend is.
Mr. Khan, learned counsel
taking
for the
some time.
petitioner further submits that the respondent number 4 may be directed to produce the answer scripts before the court. Pair is accordingly allowed. The counsel for the respondent number 4 is directed to obtain necessary instruction in this regard and to apprise this court before next step. List the matter on when?
As per your lordship convenient.
After vacation? then?
Yes, ma'am.
After vacation.
But a copy of the affidavit filed by my learned friend may be furnished to us. Sir.
Copy was also not served to me, Lordship. I have.
He has also not got by us.
Perhaps in this case, Lordship, no.
Mr. Biswas, learned counsel for the respondent number 5 submits that he has not been furnished a copy
Yes.
of
He will furnish, but he will
copy
furnish.
of the affidavit furnished by respondent number 4. The learned counsel for the respondent number 4 is accordingly directed to furnish a copy of the affidavit to Mr. Biswas during the course of the day
Today
and
possible.
also to Mr.
Tomorrow,
Khan, learned
tomorrow.
counsel for the petitioner.
Deep problem.
As per office note dated 12/9/24, up to date status report has not been received by the registry. Whether any evidence taken or not, man. Have checked the office note. The flag, man.
Office note dated 12/9/2024
12/9/2024
indicates that the scanned copy of the status report, scanned copy and status report has not been received by the registry. Accordingly, it is provided that registry shall issue reminder to the learned court below to transmit the scanned copy of the record and also the status report without further delay. List the matter on when?
The next week, man, 23rd, man.
23rd. Short date?
Man, 19, 20, any man. Or 20, man, 20.
19. 19. Next.
19.
Correct. Appealant before your lordship is referring this appeal against the judgment and order dated by your lordship will find page 12. The question here is very simple, small one, my lord. The learned Munsif has found that one part of the fact, that fact, my lord, the appointment, the system by which appointment was made, that was found illegal and there were some irregularities. But being declaratory, my lord, declaratory suit, as it was a matter of contract, so under 41C of the my lord, E of the my lord, the specific relief act, he cannot pass the pass it consequential, there cannot be any consequential order. So he cannot pass a declaratory declaratory decree. That was the observation by the learned the Munsif. Then that in the appeal, the lordship will find. If your lordship will find the appeal, that funding has been accepted by the learned session judge, the civil judge. Page 19, my lord. Page 19, your lordship will find. Page 19, paragraph 17 is the point.
So, whether all the respondents are represented, you are representing
Your Lordship.
all the respondents,
Not all the respondent, your Lordship. Except 6, your Lordship.
except 6, you are representing all the respondents. Who is for respondent number 6 then?
My lord, earlier they appeared in the because this was in the limitation proceeding, they were there. Probably name has. Private.
So whether notice was served upon her.
This was served and she appeared in the my lord, the delay condonation petition. They appeared in the delay condonation. Now name has not been shown. My lord. Probably.
Yes.
You know, fresh notice may.
So would it be proper to hear the matter?
Then your lordship may issue notice, like that. Your lordship may issue notice in this appeal to respondent number, my lord.
Third, Mr. Paying, learned counsel for the appellant, and Ms. Kokan, learned counsel for the respondent number 1 to 5.
If your lordship permits, may I go through the records, my lord, whether notice has been served to the respondent?
Okay, we'll take it up after 5 minutes.
Yes, sir. Let me go through the record.
Third, Mr. Paying, learned counsel for the appellant, and Ms. K. Fokon, learned counsel for the respondent number 1 to 5. None appears for the respondent number 6. There is no record of service of notice upon respondent number 6. Accordingly, it is provided that notice be issued to the respondent number 6 by registered post with AD and also by usual process within a return to that. Dusty is also permitted.
That's the capital.
Please the matter of fact. 4 weeks.
Oh, let's.
May, please, Lordship.
Yes.
Lordship, this is the second appeal against order dated judgment and decree dated 15/2/24, entitled appeal number 1 of 22 from Borpeta. Lordship, what happens? We lost both the cases. We filed the appeal. The suit was decreed. Original suit was decreed by the order dated 25/11/21. Title suit number was 105 of 2011. Lordship, here the only question is that actually the present appellants before your lordship are the purchasers from defendant number 1, who was the kin of the plaintiffs. Lordship, her father got 1.5 bighas of land by Sarikdar relationship. What happened? There were 4 brothers. 2 brothers purchased the land, Mohan and Kalu. So one plot was purchased in 1939 and other plot was purchased in 1940. 4 bighas and 2 bighas respectively.
But tell me whether service is completed here.
Service, Lordship.
Yes.
Service no lordship. It is for the first time actually the case is
So this is for the first time.
first time.
Acha,
Earlier
acha,
it was,
okay,
it was,
okay.
earlier it was listed before his lordship's MK
Yes, yes.
Solita. Then
Yes.
lordship, his lordship
This is yet to be admitted.
yet to be admitted. His
Okay.
lordship heard at length and thereafter directed us to file amended substantial questions of law.
Hmm.
At that point of time, the points substantial question of law raised by his lordship was that if this can be put that way,
Hmm.
it was found little bit difficult in view of the textures of the case, lordship.
Hmm.
So we have also filed the amended
Okay, okay,
substantial questions of law.
okay.
Lordship will find at page 6. It was filed in 13.8, Lordship.
Yes.
So those points were there. Here, what happens? One point I would like to place before you, Lordship.
Hmm.
That is that they are scheduled Suitland in the plaint, Lordship. Schedule B, according to them. At page 13, your Lordship may kindly find.
Yes.
Lordship, the schedule B is the Suitland for 1 bigha 4 kathas of land. There are 2 plots of land, they have split.
Hmm.
Next, Lordship, the schedule C land, they want dispossession of the present appellant's Lordship from only 1 katha and 1.5 lesa. So,
Hmm.
Lordship, 1 katha, 1 bigha, almost 2 katha, 2.5 kathas is in our possession still, and they have no claim over that. But they have claimed that the sale deed by the defendant number 1, who is not appellant here, Lordship,
Hmm.
and we are the purchasers, bona fide purchasers for value without notice. And her name was mutated wrongly according to them. In any case, Lordship, mutation may not be the proof of title. Yet they cannot claim that the entire sale deed should go.
Hmm.
So far their party is concerned, that is a different thing, even if
Hmm.
the allegation is true, Lordship.
Hmm.
Now, in such circumstance, Lordship, my present case is that Lordship may kindly turn to at page 6, Lordship, the substantial question number 3. Two and 3, Lordship.
Hmm.
The suit cannot be decreed as a whole.
Hmm.
Their claim is for 1 bigha 4 katha, and they wanted eviction only for 1.5 lesa. 1 katha, 1.5 lesa. So it causes hardship. Lordship, I am still in possession.
Hmm.
And the one pertinent point is also there that there were 2 DAG numbers, 510 and 512. So only in 501, how can they claim the entire land? 510, the plaintiffs or the defendants, that is the respondents and the appellants, Lordship, they have got in total 2 kathas of land. In total 2 kathas of land.
Hmm. So according to you, this question number 2 and 3 are relevant.
Mainly, Lordship, these 2 are. Other things pertain to, Lordship, certain technicalities as to the justice dispensation system in the subordinate courts.
Okay. Heard Mr. L. Talukdar, learned counsel for the appellant. This appeal is directed against the second appeal under Order 22, Rule 1 and 2 of the Code of Civil Procedure. Is directed against the judgment and decree dated 15/2/2024 passed by the learned Civil Judge Senior Division Barpeta in title appeal number 1 of 2022, by which the learned Civil Judge Senior Division, Borpeta, has upheld the decree dated 25/11/2021 passed by the learned Munship number 1 in title suit number 105 of 2011. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and decree dated 15/2/2024 passed in title appeal number 1 of 2022, and also the decree passed by the learned Munship number 1 arising out of title suit number 105 of 2011. The second appeal is admitted on the following substantial question of law. Number 1, whether on the basis of their disputes alleging disposition, stroke, deprivation from Schedule C land measuring 1 katha 1.5 lesser land, the plaintiff stroke respondents are entitled to claim decree of cancellation of cell deed number 1142 of 2010, dated 16/6/2010. Exhibit 9. Number 2, whether without materials on record the appellants inherited joint rights in the suit land bearing DUG number 385 old stroke 510 new could be denied stroke taken away by the respondents stroke plaintiffs merely because their predecessors in interest did not question the transfer of the land by the other joint owners, comma, the father of defendant number 1 in another DUG number 539, which will make it old, stroke 512 new, the subject matter of Exhibit 1 and Exhibit 2. The court may also consider framing of additional substantial question of law after giving notice to the parties if deemed necessary at the time of hearing. Admit. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar will call for the record from the learned.
Civil Senior Division.
And also from the Court of Munship. Both the records will be required. Call for the record of title suit number 105 of 2011 from the Court of Learned Munship number 1 Borpeta, and also title appeal number 1 of 2022 from the Court of Learned Civil Judge, Senior Division Borpeta. List the matter after 4 weeks.
I Lordship. Staying the execution.
Stand straight till return till disposal of the appeal.
Highly obliged.
May I be allowed? Lordship has had the matter earlier occasion, my lord. I'm just trying to refresh your lordship memory. My lord, this issue before your lordship is no way connected with the merits of the cases, my lord. It's relating to the wrong interpretation of the court's order and relating to the kind of procedural law, adjective law, not even a substantive law. As a result, my lord, infringement of fundamental rights of the petitioner, my lord. Since right to free, fair and fair trial is my fundamental rights, my lord. Lordship, kindly come to the page number 56, Lordship.
Yes.
This order, my lord. May I read, Lordship? Since the petition 194 filed by the defendant with a grant further time to cross examination PWs on the ground that the learned counsel inquiring on the defendant is out of state and taking treatment for his backbone injury. Peruse the petition along with the case record heard. On perusal of the case record, I have observed
that the dated so and so matter is pending at the stage of PW1. And till today, the defendant side has been granted 11 numbers of adjournment in this whole pending cases. We mentioned that it is the earlier orders, the defendant also has been directed to pay the cost of the amount of taking such adjournment, but no such court amount has been paid by the defendant till date. Moreover, I have also observed that although the defendant side has been taking adjournment on the ground that the element of his engaged learned counsel, but in respect of the no medical documents has been submitted before this court sustaining such facts. Therefore, in view of the above, as well as the considering the grounds of the present petition, I don't find any justified reason to allow the prayer for the petition as order defendant side was granted last opportunity to conduct a crossing PWs. Accordingly, prayer of the petitioner is then rejected. The conduct of the parties, both the parties are appreciable. I do admit, my lord. For that, my lord, defendant is debarred from the conducting the cost of the PWs. He has been penalized. Next line is important, my lord. Fixing 31,719 for DWs for affidavit. This is the order, my lord. Then, my lord, we approach the Honorable High Court, my lord. Honorable High Court confirmed the landed Musib order. Fixing 31,719 for the DWs, my lord. Subsequently, this order had been reviewed by the learned Munsif, my lord, although he has no refusal power, my lord. Kindly come to page 60, lordship. Lordship has found.
Yes.
Plaintiff has submitted certificate of the order passed by the Honorable High Court, so and so, dismissing the petition against the impugned order, so and so. So we are bound to honor the order passed by Honorable High Court, my lord, although we have taken grounds for COVID and all, my lord, that was not convinced by the Honorable. Accordingly, the instant case shall proceed as per law to the stage of argument. My lord, earlier it was fixed for DWs, my lord. He has been revising all order, my lord. Thereafter, my lord, we approach the Honorable High Court, my lord. The order is the order, my lord.
So you have not enclosed that order with this petition?
My lord, not enclosed. It is
Not
subsequently, my lord. Subsequently, my lord. It is known to them, my lord. Heard Mr. Mary Lordship.
Yes.
Heard Mr. M.U. Ahmed, the learned counsel appearing on behalf of the petitioner. The court has perused the order impugned in the instant proceedings, and more particularly the order dated 5/1/12, whereby the petition number so and so to provide defendant opportunity to file WS was rejected in the light of the order passed so and so. It appears from the record CRP number IO 41C was filed against the order dated 12/7/19, whereby trial court has debarred the petitioner who has defendant in the suit to cross-examine PWs and further and fixed 31/7/19 for DWs and affidavit. DWs affidavit. This court had order dated 17/1/11 had upheld the order dated so and so. Accordingly, directed the land court to proceed with the disposal of suit according to law. Consequently, the stage of proceeding would have been stage of filing of DWs as he passed on 31/7/1, for which the petitioner herein had filed an application to grant them an opportunity to adduce the defendant witness. But the filed impugned order dated so and so, the same was rejected. It is against that instant petition and filed, my lord. So my humble prayer, if your lordship at present, my lord, whatever the authority opinion given in Honorable High Court, we must honor, my lord. I have been penalized, my lord. I have no hesitation on that, my lord. I must honor that order, my lord, because I am debarred from cross-examining DWs, my lord. And they are objecting now, my lord, this authority finding of the Honorable High Court, my lord. That is my submission, because I am debarred from cross-examining DWs. Half of the case they have owned, my lord. So DWs, my lord, since Learned Munsif has already passed the order fixed for DWs, my lord, that can be reviewed, my lord. And nowhere in this order is disclosure of defense witness, my lord. Clearly says that the stage of proceeding would have been stage of filing Ws. That is I want. Whatever the Honorable High Court giving the findings, my lord, I am on that, my lord. That is my simple submission, my lord.
Yes, Mr. Singh.
My learned brother is totally misguiding the Honorable Court. If the two facts are laid before, I would have loved to concede my lord. Now, this is not the case, my lord, that DW was closed forever. DW already had been done long back in the year 2014. There was a minor amendment, a small portion over which the DW was closed subsequently because of their failure, my lord, because they never appeared even to cross-examine the plaintiff, and subsequently they did not lead their own evidence. Now, kindly come to two facts, my lord, what they have produced before this honorable court. Kindly come to page 56 again, my lord. Kindly look at the date. The date of order, my lord, of the Munsif, 12/7/2019. And kindly come to page 60, my lord. The order that they have produced. It is 4/1/2022. Now, the million-dollar question, my lord, will be what happened between 19 and 22? What you were doing? Whether there was any sort of stay by this Honorable High Court in the pending revision? If yes, when your revision petition was actually filed, what has happened? They have maintained total silence. They have not produced any single document at the time of the CRP. Now, kindly come back once again to Annexure 7, my lord, page 57. The previous order dated 12 July 2019 was challenged by them before this Honorable High Court. And what was the order that was passed? That is finding reference at page 57, Annexure 7, my lord. 17/11/21 is the date order. Heard so and so, appearing on behalf of so. This is an application filed under Article 227 of the Constitution of India, challenging the order dated 12/7/2019, whereby the application filed by the defendant praying to grant further time to the plaintiff was rejected on the ground that since 22/11/2017, as many as 11 adjournments have been taken by the defendants. The provision of Order 17, Rule 1, post 2002 amendment of CPC has made it clear that no adjournment shall be granted more than 3 times to a party during the hearing of the suit. In the instant case, the petitioner had taken 11 adjournments since 22/11/2017, and consequently the court below was justified in passing the impugned order. So, 12/7/2019, the order that was challenged was put at rest by this Honorable High Court by its order dated 17/11/21. Again, I am putting a question. What happened in between? Kindly come to the affidavit in opposition, my lord. When this revision petition itself was filed, kindly come to page 69, my lord. Just now, the order that I have shown to the Honorable Court, dated 22/11, my lord, that revision was filed, page 69. Annexure B, my lord.
Annexure?
B.
Yes.
Page 69, my lord. When this revision was filed, kindly come to the top portion, my lord. Filing date is 9/12/2019. And the registration date is 18/12/2019. At the top, my lord. Annexure B. Now, what has happened, my lord? Since July 2019 till December 2019, the orders were regularly passed by the learned Munshi, and the defendant was appearing. What was happening there? Now, kindly come to page 71. This is the order, my lord, of 12/7/2019, Annexure C, my lord. Thereafter, 14/8/2019, next page, my lord. Presiding officer was on leave. 72, my lord. Page.
Yes.
Next date is 3/9/2019. Plaintiff presented by so-and-so petition. Defendant side again sought for an adjournment on the ground of ill health condition of his engaged learned counsel. Your lordship will remember that by order dated 12 July 2019, the matter was fixed for recording of DW. Now, on 3rd September 2019, defendant side is seeking time on the strength of medical documents to lead their evidence. 19th September, my lord. Defendant side sought for an adjournment on the ground that he preferred a civil revision petition before the Honorable High Court against the order of this court, perused the petition, heard, no copy of order or any document sustaining such fact has been filed with the petition. Now, my lord, when he is saying on 19th September, but your lordship has already seen Annexure B, that for the first time the revision petition was filed in December. In September 2019, this defendant made the trial court to believe that he has already approached the Honorable High Court, a revision has been filed. September. Now, what was done by the learned trial court? However, page 73, my lord, second paragraph. However, considering the fact that the defendant has approached the Honorable High Court, prayer allowed with a direction to the defendant to place, form and the certified copy of order passed by the Honorable High Court, wherefrom they will produce, when the matter itself was never presented or filed, my lord. So in September, he is misguiding the learned trial court. 4th October 2019, my lord. Plaintiff represented defendant by petition number so and so again sought for further time to DW. He is seeking time for DW in October 2019, which is allowed for the last time. Now these orders are passed and these orders have never been put to challenge, my lord, even till today. Now kindly come to page 80, my lord. The subsequent order is on 28/11/2019. This order again is not under challenge. Page 80. Plaintiff represented, right? Petition number so and so, defendant side sought for further time to submit DW evidence on affidavit on the ground that he had preferred a civil revision before the Honorable High Court. When he is saying, my lord, in November 2019, till then no revision was filed. Against the previous order passed by this court, and the same is under the preview of the Honorable High Court. Peruse petition along with the case record heard. On perusal of the case record, it appears to me that since 19/9/2019, the defendant side has taken already 2 number of adjournments on the ground that he had preferred a revision before the Honorable Guwahati High Court. But in spite of the direction from this court regarding submission of any certified copy of order passed by the Honorable High Court in that respect, he has not submitted by defendant side before this court. Today also no certified copy of order has been annexed with the petition preferred by the defendant side. Considering all this, I have observed that it is an old pending case of 2010 and the defendant side has been delaying the proceeding without any satisfactory and convincing reason. Therefore, I don't find any justified ground to accept the prayer of the petition and the same stands rejected. Now, these orders, my lord, whatever order has been passed post 12 July 2019 till November 2019 has never been put to challenge. Now, what they have done, they have produced along with the revision petition one order of July 2019 and the other order of 2022 January. In between all the orders, they have suppressed. Now, unless these orders are put to challenge and are set aside, my lord, whether the clock can be taken back. The matter was already posted for argument, and your lordship will find that Hyde Annexure B, the revision petition, that is the previous revision petition itself was never submitted, though they made the learned trial court to believe that a revision had already been preferred, which in reality was preferred only in December 2019. So these are the conduct, my lord. The person who is seeking equity and is saying, seeking equity, praying leniency, my lord, whether he has come with clean hands. And unless these orders, which are interregnum order, my lord, between July 2019 and December 2019, by which time many orders were passed, whether before, without setting aside these orders, which are not under challenge, can the clock be taken back? All sorts of tactics, my lord, has been adopted by the defendant just to prolong and delay the ultimate adjudication of the dispute. And I again said that in 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was completed. One amendment was done because ultimately he tried to dispossess the plaintiff. 2014-15 itself, DW was in 2015, one portion was amended, 3 lines were added, for which additional evidence was required to be adduced, my lord. Plaintiff adduced, no cross-examination. Defendant side is failed to adduce any evidence, and he, my lord, he was not supposed to adduce what he was going to say. So that is why he tried all sorts of maneuvering, my lord, in order to prolong. And your lordship already has seen that between July 2019 and December 2019, all the orders were passed and those are not under challenge. And they kept informing the learned trial court that we have preferred revision, which revision your lordship has already seen was filed in reality in December 2019. So they challenged 12/7/2019 order, which was ultimately not accepted, and all subsequent orders have attained finality. They have only chosen to challenge order dated 5th of January 2022. In between orders, they have suppressed. Had they come with clean hands and thereafter
No,
sought
they have enclosed those orders.
No,
which
these
have
are
been issued.
enclosed by us, my lord. These are enclosed by us, not by them.
Not by him, not
They
by the
suppressed.
petitioner.
Yes.
Not suppression, Lordship, because we had agreed from the last order that Learned Munshi has fixed the date for DW's, my lord. After this, DW's after amendment, my lord, they have amended, twice amended, my lord, petition. That is it. Even in your lordship, my lord, in the light of the comparative concept of the equality clause, Article 14, my lord, they have also taken so many time, my lord. On 12, that is in page 84, my lord, they have added, my lord. 12, 21, 520, both parties absent. That is the COVID period, my lord. Again, 10/6/20, absent, my lord. 23/9/20, absent. 5/11/20, court was resumed, limited court, both parties absent. 21/20, court is working, plaintiff is absent. Plaintiff was absent, my lord.
May I?
21/20, sides, steps. 7/5/21, both side absent.
Let him complete. Let him complete.
7/5/21, both side absent. 19/6/21, both side absent. 6/8/21, both side absent. 19/6/20, both side absent. Because I am not hesitating all these things, but that was the COVID period, madam. What my learned submission made, my lord, that I have concealed the matter, suppressed the matter, not suppression at all. Last order, the learned Munshi fixed the date for DW, and Honorable High Court lastly, my lord, confirmed that that should have been from the date of from the stage of DWs, not for the argument. That is my simple, my lord. Whatever, my lord, earlier, my lord, negligence of my the petitioner, my lord, he has been penalized. He has been debarred from cross-examination DWs, my lord. Already penalized. Again, reopening all these, my lord. That was the reason, my lord. He was debarred from cross-examination DWs. Second time again, he cannot be penalized, my lord. The last 3 occasions, my lord, that is the interpretation of the court's order. He has fixed for DWs and his own order reviewed, my lord. Whatever his negligence, my lord. Both party negligence, that time it was not highlighted, my lord. Remain as a sub-silence, my lord. I'm not on that, my lord. Whatever the negligence committed by the petitioner, he has been penalized. Debarring from cross-examination DWs means half the own case has been owned, my lord. Nothing else, my lord. If I am debarred from reducing defense witness, my lord, after that is second amendment, my lord, then Learned Munshi can pass the decree, my lord. Not necessary my presence. So these are all the procedural law and substantive law, my lord. It is the infringement of my fundamental rights, my lord. Try to free, fair and fair trial. and constitutional law are the supreme of all, my lord. Above the substantial law and the procedural law or adjective law. That is my submission. Whatever earlier did, my lord, for that he has been penalized. Dividing from cross-examination is a huge loss to the petitioner. He cannot cross-examine, my lord. For that, those negligence, he has been penalized. So for filing date, my lord, he has given the all relevant documents to the advocate who is in Guwahati, my lord. Maybe 2-3 delays, sometime delays, my lord, in filing, my lord. That is not suppression. Non-filing on by revision and delaying in filing different thing.
Okay.
So my humble submission of whatever the order passed by the Honorable High Court lastly on 5/1, my lord, I have submitted your logic. That must be honored, my lord. That is my submission.
I was trying to show my lord, my learned brother is saying that in the year 2020, there was no representation from either side, and side by side, he is also saying that it was COVID period. Now, just to refresh the memory of this Honorable High Court, 12 July 2019 is the order that was challenged earlier, my lord. Kindly again look at Annexure B, my lord. Why I am highlighting? Because this revision was filed only in the month of December. While in between July to December, he kept on informing the learned trial court that he has already approached. He has already preferred a revision. And the learned trial court was asking for a copy of an order. So your lordship will find page 69, 9th December is the date when the revision was preferred, which revision ultimately was rejected on the ground that he had taken 11 adjournments and there was no kind of leniency to be shown because of Order 7, Rule 1. And the same Order 17, Rule 1 again will come into play. During this period, there was no stay. There could not have been any stay because the revision itself was not filed. Annexure B, my lord, page 69.
No, I have seen it.
And thereafter, my lord, once in December 2019, this application was filed and it continued up to 2021. In between the periods, both the parties knew that the matter is sub judice before the High Court. Therefore, the ultimate adjournments were granted because the matter was sub judice during that period, in between December 19 and November 2021. Now, again, I am saying, my lord, that I would have loved to concede, but kindly look at the conduct, whether the conduct of the defendant demand any sort of leniency, and whether in the absence of any challenge to any order that was passed post 12 July 2019, between 28 November 2019, my lord, all the orders have already attained finality. And during this period, there was no challenge to any of the order. Now, all of a sudden, you are challenging only one order, that is of 5th January 2022, without praying for reversing or setting aside the previous orders, my lord. Can the clock be taken back? Those orders need to be challenged.
Okay.
Okay. Obliged.
So, my lord, last submission, my lord. Lordship is not going to pass any order supplemental to the order passed by the Honorable High Court, my lord. So far, my lord, the date fixed by not by me, my lord, 31/7 for DWs, the Munsif itself, my lord. He has all aware of the proceedings, all dates, my lord. He has fixed the date, my lord. Against that, I have come, my lord. Subsequent, earlier, my lord, I am admitting, my lord, both the conduct of the both the parties not appreciable. Both the parties, my lord.
I have objection, my lord. Time and again, he is saying about the other parties' conduct.
So many
Wherefore he derives the right.
So far, 11 adjournment, my lord. My learned brother is again hesitating, my lord. That has been taken into account, my lord. And considering those 11 adjournment, my lord, I have been debarred from cross-section DWs, my lord.
Okay, you have already submitted that aspect. Appraise this court. Third, Mr. M.U. Ahmed, learned counsel for the petitioner.
Last
Mr.
liberty, my lord. Last liberty. My learned brother is referring to the order of this Honorable High Court passed on 8th of June 2022. At that period of time, it was at motion stage, we were not in picture. And this order was generated only because ultimately the orders of the learned trial court between July 2019 and December 2019 were not produced. And what has happened, my lord, the Honorable High Court had said that within 3 days, if you don't take steps, this order will stand vacated. And ultimately it stood vacated because they again took steps, my lord, after 5 months. We have produced our affidavit. They took steps after 5 months.
Okay, I will peruse your affidavit.
Obliged.
Mr. S.K. Singh, learned S.K. Singh, respondent in person, and Mr. Pusilal for respondent number 2. Argument concluded, order reserved.
Obliged.
Last word, my lord.
No.
14 could directly deposited deficit amount of 10 rupees, my lord. On 16, I had deposited. On the
No, on the other day you have submitted that.
My lord, my lord.
None appears for the petitioner on call. It appears that on two previous occasions, 21/8/2024 and 12/8/2024, the petitioner remained absent. In view of non-representation of the petitioner, this court find no just ground to adjourn the case to another day, and accordingly, the same instance dismissed.
26.
Lordship.
Hmm.
The case RAS, original case is second appeal. But in during the pendency of the appeal, some of the respondents expired. And that is why we have filed some miscases for condemnation and also for substitution. The office note already allowed, and office note also shows on the dated 38/24, the office notice is there. Already substitution has been made, as paid for. Office note 38/24. Now, Lordship, thereafter, this.
So, thereafter, whether notice was issued?
Thereafter, this miscase 603 has come up.
Acha. Now, notice has to be issued.
No, Lordship, they are as per post list, they have held one caveat, but here the negative layer is restricted, so it is their knowledge to this. While the 603 is a definition, the earlier they filed a caveat.
N. Goswami. Simple. N. Goswami. Huh? So the court pastor will call the council. We will take it up in the second half at 2 o'clock.
May I please, Your Lordship? My lord, this is regarding non-payment of salary, my lord. My lord, petitioner was appointed in the year 1989, and thereafter his salary has been paid up to March 2013. Thereafter his salary has been stayed, not paid. My lord, this petitioner filed a petition, page 17. The last portion, my lord, Honorable High Court passed an order. All the respondents appeared, my lord.
So, madam, you have for respondent number?
My lord, I'm appearing on behalf of R. Mazumdar, standing counsel for the department.
Yes.
He's on legs under court. I pray for time being.
So, at 2 o'clock then, let him appear at 2 o'clock. None appears for the petitioner on call. Rest is the matter after vacation.
31.
May I please, my lord?
Yes.
The service is complete.
Pardon?
Service is complete.
Service completed.
Yes, my lord.
Record received?
Yes, my lord. As per office note dated 11/8/2024.
Heard, Mr.
G. Imtiaz, my lord.
G.
Imtiaz.
Learned counsel for the appellant and madam.
P. Hajarika on behalf of R. Chaudhary.
Learned counsel appearing on behalf of Ms. R. Chaudhary, learned counsel for the respondent. It is submitted that service completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that rest is the matter for hearing immediately after reopening of the vacation.
Yes.
If I may, my lord, notices were issued to respondent number 4, 5, and 6. As per office note dated 3/38/2024. However, my lord, AD card of only respondent number 4 has been received without any signatures. My lord, we shall have to take fresh steps upon these respondents.
Okay. And in a respect of 5 and 6,
5 and 6, nothing has been received by.
so you want to take fresh step upon them?
Yes, my lord. 4, 5, and 6, my lord.
And in respect of other respondents,
My lord, other
1 to 3,
service
or
has
1 to
been
4,
completed.
1 to 3, yes.
Yes. Only 4, 5, 6 has to be.
So in respect of 1 to 3 completed.
Yes, my lord. My lord, it is reflected in the cause list as well.
Okay. Heard Mr. So-and-so, learned counsel for the appellant. Office note dated 30/8/2024 indicates that AD card in respect of service of notice upon respondent number 4 returned without any signature of the recipient. The learned counsel for the appellant submits that he will take fresh issue upon respondent number 4. Office note also indicates that neither AD card nor answer notice in respect of respondent number 5 and 6 returned till date. The learned counsel for the petitioner appellant also submits that he will take fresh issue upon them. Accordingly, it is provided that the learned counsel for the petitioner appellant shall take first step upon respondent number 4, 5, and 6 by registered post with AD and also by usual process within a week from today. None appears for the rest of the respondents, though the name of their engaged counsel has been reflected in the cause list. List the matter after 4 weeks.
Yes, deeply.
None appears for the petitioner on call. Recess shall list the matter after vacation.
Lordship, in this case, 34.
Yes.
The dispute is was academic dispute, but unfortunately the petitioner has already died. Yes. So
Pardon?
matter may be closed.
Pardon?
Petitioner has already died.
Died?
In the meantime.
Acha.
So this matter may be closed.
Heard Mr. UC Rava, learned counsel for the petitioner, and Mr. Thakuria, learned counsel for the respondent. Number
1, 2, and 3, Lordship.
1, 2, and 3. Mr. Rava, learned counsel for the petitioner, submits that the petitioner already suffered demise, and his legal representative are not interested to pursue the matter. His legal representative are not interested to pursue the matter.
No. This is an individual case.
Acha.
Process of some seniority.
And as such, the matter may be closed. Accordingly, this repetition stands closed.
Because the LCR is there, it can be posted for hearing.
Pardon?
The matter can be posted for hearing. The records are.
Hearing.
Yes.
Service completed.
One is there, one person has died, possibly during the pendency of the suit or appeal, so that we have to file application for striking off, otherwise also not relevant. My colleague is appearing for one of them. We are there.
Acha. Both the parties are duly represented by their engaged counsel. It is submitted that service completed and LCR has also been received, and as such, the matter may be listed for hearing. Accordingly, it is provided that recess shall list the matter for hearing immediately after reopening of the vacation.
May it please your lordship. Lordship, I am appearing on behalf of Mr. S.P. Chaudhary for the appellants. Lordship, kindly peruse the office note dated 28/8/2024. Lordship, here learned counsel have appeared and entered appearance on behalf of respondent number 6. Lordship, And other respondents, respondent number 1 had expired, 2 also expired, and in respect of respondent number 3, service report is duly served. In respect of respondent number 4 served, respondent number 5 also duly served, respondent number 7 also duly served, 8 has been accepted, and 9 addressee left, 10 addressee not found, 11 not found, and respondent number 12 not found, Lordship.
Pardon, Miss, your good name?
Miss B. Devi, Lordship.
Learned counsel for the appellant and madam?
R. Chetri, for respondent number 6.
R. Satri for respondent number 6. Office note dated 28/8/2024 indicates that notice issued to the respondent number 1 and 2 returned with a report that both of them already suffered demise. Notice issued to the respondent number 3 returned with a report that duly served. And in respect of 4, returned notice returned with a report that the son of the respondent number 4 received the notice. And in respect of respondent number 5 and 7, it is stated that notice has been duly served upon them. And in respect of respondent number 8, it is stated that notice has been served with the husband of the respondent number 8. And in respect of respondent number 9, it is stated that addressee left. And in respect of respondent number 10, it is stated that addressee not found. And same report is given in respect of respondent number 11 and 12. Accordingly, it is provided that the learned counsel for the appellant shall take fresh step upon respondent number 9, 10, 11, and 12. And you have to take a step for substitution of legal heirs of respondent number 1 and 2. Yes. It is further provided that the learned counsel for the appellant shall take necessary step for implementing the legal heirs of respondent number 1 and 2. List the matter after 4 weeks.
Deeply obliged.
Very good.
That part, otherwise LCI is received from the.
So, if the appeal is ready for hearing, we can.
We have a stay petition also. We have a stay petition. We have a IF for stay the
Acha.
operation of the order, and that particular ILOC, last occasion they have short time for filing affidavit, filing reply also.
My lord,
No,
only
can we
liberty
not
was.
finally dispose of the matter if appearance is completed, LCR is received?
Yes, my lord. My lord, I beg to submit that in this matter, in appeal, page number 8, page number 7, and paragraph number 4 and 5, it is admitted by the appellant that show cause notice has not been issued before imposition of the penal under charges. And my lord, since there has been an admission, and also in the LCR, my lord, an affidavit has been submitted wherein the admission has been made that show cause notice has not been served. My lord, in light of the admission and in light of Order 12, Rule 6 of CPC, a speedy judgment is expected, my lord, and my lord, be pleased to grant a short date for the speedy judgment, my lord.
Yes, before vacation, we will try.
Yeah.
Reported loss whether they have to file reply in the miscase or not. That part we.
My lord, I am very much prepared to submit all my objection orally. My lord, I beg liberty from the court to submit all my objection orally.
No, if we finally
My
hear and dispose of the matter, then where is the question of granting stay?
Then also that part also we have no objection. So Lordship may fix it after vacation also.
My lord, a short date may be granted.
Before
Like
vacation,
Order
we will
12,
try.
Rule 6, my lord.
Before vacation?
Lordship.
Order
Both the parties are duly represented by their engaged counsel. It is submitted that service has already been completed and LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that registrar shall list the matter before vacation 26 September.
26, I have difficulty, any other days?
30.
Lordship.
Much obliged.
For hearing. In IA takedown, heard Mr. So-and-so, learned counsel for the applicant, and Mr. Sharma, learned counsel for the respondent. Mr. Sharma submits that he may be granted 1 week time to file objection. 1 week.
My lord, I beg liberty from the court to submit all my objection orally. I am very much well prepared, my lord. The question of law is covered by the divisional bench.
That's all right. When you will be able to file this objection?
My lord, in 72 hours, 3 days, my lord.
17?
72 hours, 3 days, my lord.
Oh, within 3 days, you will file objection in this petition and press for granting him 3 days time. Here is allowed. Recessal is the matter, along with MFA number 43 of 2024.
Much obliged.
Your Lordship, as per office note dated 3/8/2024, service weight 88 to receive.
Heard, Mr.
A. Mena.
Learned counsel for the applicant. Office note dated 3/8/2024 indicates that neither service report nor AD card in respect of the sole respondent has been received. What to do? You want to take fresh step? The learned counsel for the applicant submits that he will take fresh step upon the respondent. Accordingly, pair is allowed. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Right.
49 and 50.
May applicable. Lordship, as per the direction of the honorable court, the insurance company deposited the amount. So we have filed an IA for the deposited amount for withdrawal.
What was the amount?
My lord, 1,50,000 my lord deposited.
2 lakhs.
One IA 2 lakhs and one IA 1,50,000. Two IA we have filed, my lord. 49 and 50, my lord.
Lordship, subject to furnishing of indemnity bond. Yes.
Why?
Lordship, because Lordship, in this case, we have no liability, Lordship. And
How?
because Lordship, we have challenged the contrary findings of the ability of DL, Lordship.
DA means?
DL, Lordship.
DR.
DL, driving license, Lordship.
What is the ground?
Yes, Lordship. Para 4 and 5, Lordship.
Yes, what is the ground?
Lordship, in the main memo of appeal, page 4, Lordship, and ground para 4 and 5, Lordship. May I read, Lordship?
Yes.
Whether in view of the settled position of law as notified by the government of Nagaland under MV Act from the time to time, the learned commissioner is justified to arrive at a contrary findings pertaining to the validity of driving license of the driver was found to be not valid as RTI replay of the concerned DTO lordship.
What was the reply?
Reply was not received, lordship. We have filed the RTI.
No, that's why I'm asking you, what is the reply of RTI?
That reply was not received from the RTI, lordship.
Not received.
Not received. We have filed the RTI, but reply was not.
Then how can you justify your claim?
That will argue my senior lordship at the time of hearing.
Pardon?
That will argue by my senior lordship at the time of hearing. And as today, as per his instruction, lordship, I'm submitting.
Sorry, we will not direct him to execute any indemnity bond. Without any rider, we will allow the petition. Heard, Mr.
F.A. Hassan.
SN?
F.A. Hassan.
F.A. Hassan, Learned Counsel for the applicant, and Mr.
A.R. Das, lordship.
A.R. Das,
On
Learned
behalf of
Counsel for the respondent number.
I am for the appellant insurance company.
For the appellant. No, in this application.
In this application, lordship, I am for respondent number 1, lordship.
Respondent opposite party number 1.
1, lordship.
And for opposite party number 2.
For the, and Mr.
M.
Learned Counsel for the respondent number 2. This interlocutory application is preferred by the applicant, Wahida Begum, for allowing her to withdraw a sum of ₹2 lakhs, which has been deposited by the appellant Oriental Insurance Company Limited with the registry of this court, pursuant to order passed by this court in MFA number 05 of 2024 by order dated 24/1/2024. Here is the application and the documents plus on record. After hearing learned advocates of both sides and also considering the facts and circumstances on the record, it is provided that the amount deposited with the registry of this court shall be released in favor of the applicant, Wahida Begum, after due identification. In terms of above this, IA stands disposal. Same in IA number 2352. Yes, same order.
51. Obliged.
Lordship, I'm for the appellant in this case. We were substituted by the order dated 38/24. Accordingly, we filed our wakalatnama, but due to some technical issue, the same has not been listed along with the record, lordship. The same has been corrected today. As because of that, our name has not been shown in the wakalatnama. And the respondent side has filed a injunction petition. We wish to file an objection against the petition.
Mr. Day, you are for?
I am for the respondent number 1 here in the applicant in this case number.
No, in
2561.
RSA.
2651. In this
In main appeal.
sole respondent.
Acha. Heard, Mr.
B.S. Deka.
B.S.
B.S. Deka.
Deka, Learned Counsel for the appellant, and Mr. Day, Learned Counsel for the respondent. Mr. Deka submits that he has newly been engaged here in this appeal, and he has already filed his power, but the same is not placed on record, and accordingly it is stated the matter may be listed after 1 week.
Well, on
25th of September. Prayer is accordingly allowed. Recessal is the matter on 25th of September.
And my lord, their prayer is that in this case number 2561, they are to file objection. My lord, notice was served long back, 19/8/2024.
In IA number 2648.
2561/24.
Okay. Okay, same arts so. Mr. Decker, learned counsel for the applicant submits that he will file objection.
Yeah.
Objection in this application on next set. Prayer is accordingly allowed. List the method on. About that. Okay.
No question.
Lordship, this I has been filed, my lord, for withdraw the RSA, my lord, on the strength of the compromise, my lord, between the parties.
Or
Compromise, my lord, both the parties has compromised the matter, my lord, out of the court.
yes, Mr. Haloy,
Lordship, I have taken instruction. They have no objection. Lordship.
no objection.
No.
Heard Mr. Mubarak, learned counsel for the applicant. This I is for what purpose?
For withdrawal, my lord, on the strength of the compromise, my lord, between the parties. Order 23 rule 3 of the cities.
The RSA has been preferred by them. Lordship. Now they want to withdraw it. As because their compromise has been arrived.
This interlocutory application under order 23, rule 3 of the Code of Civil Procedure is preferred by applicants. For allowing them to withdraw the RSA number 216 of 2017 pending before this court as per compromise agreement between the parties.
On 23.
And by treating the compromise agreement as part of the decree and to send down the record to the learned court below. Courts below. Mr. Mubarak, learned counsel, where is that agreement? NXRA.
For page 14.
Mr. Mubarak, learned counsel for the applicant submits that the matter has been compromised between the parties and an agreement was also executed between the parties, which is annexed to the application as Annexer A. Annexer A and as such, Mr. Mubarak submits that the applicants may be permitted to withdraw this RSA on compromise and to make the compromise, deed of compromise as part of the decree and to send down the record to the learned courts below. Mr. Haloy, learned counsel for the respondent submits that the respondents have no objection in the event of allowing the applicant to withdraw this RSA as the matter has already been settled between them. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition, application and the agreement, compromise agreement, which is annexed with the application as Annexer A at page number 14. It appears that both the parties have amicably settled the matter, and as such, I find sufficient ground to allow the applicants to withdraw this second appeal. Accordingly, this second appeal stands disposed of on withdrawal. The deed of agreement, Annexer A shall be part of the decree. Rest shall send on the record to the learned courts below for it with a copy of this order.
The RSA already gives, the RSA, my lord, there should be an order, my lord. In the RSA, my lord, there should be in persons of the order, RSA should be.
RSA in person to order passed in IN number so and so. This RSA disposed of on withdrawal.
53 also same, my lord.
Same matter.
Same matter, same party. Appellant is different, but respondent same.
Okay.
The same judgment.
Okay. We'll dispose of both the appeal.
Okay.
Any other?
Yes, Your Lordship. Lordship, as per the last order, we have taken fresh steps upon the respondent number 1B. As per the office note dated 13/9/24, notice has been received, unserved notice has been received back with the note that the addressee cannot be located.
Heard Ms. M. Devi, learned counsel for the applicant, and Ms. Soduri, learned counsel for the respondent number 1.
I am for respondent number 3, Lordship.
And
SP Sharma.
Mr. S.P. Sharma, learned counsel for the respondent number 3.
Your Lordship, I'm also appearing for respondent number 1A. Parag
Yes.
Thakuria.
Office note dated 13/9/2024 indicates that unserved notice issued to the respondent number 1B returned with a report with a postal remark that addressee cannot be located. What to do? You have to take fresh step.
Lordship, we already took steps twice, Lordship. Now,
But it return the addressee cannot be located. You
Located,
find out his correct address and take a step. Accordingly, it is provided that the learned counsel for the applicant shall take fresh step upon respondent number 1B after obtaining necessary instruction in respect of his address within a period of 1 week from today. List the matter after 4 weeks.